The brother was 15 at the time and an admitted crack addict. A psychologist who interviewed Percy Palmer said, "His profile does show a very troubled individual who is gullible, extremely angry, and very suspicious of others taking advantage of him. He takes little responsibility for his problems, projecting blame on others. He feels estranged and alienated from others and sees the world as a threatening place, with him being the victim or unjustly blamed for the difficulties of others." Palmer said that some of his mental difficulties could be blamed on his mother, who he believed used cocaine when she was pregnant with him. He also said he got upset with his mother when she chose to use cocaine and bring different men into their home. When he was 3, Palmer was diagnosed with bacterial meningitis and spent 13 days in the hospital. At the age of 6, another child in his home caused an explosion. There were several children living in the home with no adult supervision. Authorities determined that the children were being neglected and they were placed in foster homes, with Percy being sent to live with a grandmother. He returned to the hospital at age 8, but left when his mother would not consent to a lumbar puncture that would have shown whether he contracted meningitis again. During that visit, doctors reported smelling alcohol on his mother's breath. While he was in elementary school, Palmer was held back and was considered a discipline problem. He attended high school at Canyon Springs High School in California with little success, attaining a GPA of .75. He was able to get jobs, but never held one for more than a month at a time. He had scored a 69 and an 80 on IQ tests, where 100 was considered average intelligence. In 2003, Palmer told a psychologist that he loved drinking. He took his first drink at age 9 and was an alcoholic by age 15, drinking from the time he woke up until he went to sleep at night. He also became a marijuana user and would smoke up to a half ounce per day until he was arrested in 2001. He said he also used cocaine, opiates, and tranquilizers, and he once even tried making drugs out of embalming fluid. I personally worked for several years in the funeral industry and was assured by several morticians, making drugs out of embalming fluid is not a very bright thing to do. Every story has an element of he said and she said. This story is no different. LaTonya Taylor and Percy Palmer each had an account of the events of July 11th and 12th, and not surprisingly, each one blames the other for what happened. According to Taylor, she spent the evening of July 11th at her sister's apartment with several friends, including Percy Palmer. They drank beer, snorted cocaine, smoked marijuana, played cards, and took Xanax pills until after dark. Later in the evening, Taylor and Palmer crossed the railroad tracks and went to buy more beer at the BP station at Lowry Street. Taylor mentioned that Troy Snell owed her $400 for drugs she had sold him. We will pause here and say money he allegedly owed her. There was never a shred of proof that Snell owed anything to Taylor, or that Snell's involvement was anything more than his kindness and good nature being taken advantage of.
There was no proof ever that they had ever met before through phone records, friends, anything that they'd even laid eyes on each other before. And them being in the store next door, the BP store, leads me to believe they saw it as an opportunity because they were in the store within a few minutes of each other.
After being told of the alleged debt, Palmer said that he would take care of business, which Taylor took to mean that Palmer would go get her money. In her version of the story, she watched Palmer go into Captain D's, where he held Snell at gunpoint and walked him into the kitchen area. She says she never went into Captain D's and in fact stayed in the parking lot the entire time. She allegedly heard 2 shots and began to walk away. She looked back to see Palmer and Snell get into Snell's Mazda Protege and drive away. She continued walking, and Palmer caught up to her and was carrying a blood-stained T-shirt. Taylor said, "Percy told me he took care of business. He was laughing and said how good of a job he did. He said he made them go on their knees and had Troy tie them up. I think they were tied up behind the head. He said he had Troy put them in the freezer. He said he did Troy in. He said he shot them in the back of the head." She allegedly saw Palmer throw a bloody T-shirt into a dumpster near her sister's apartment. Palmer's story agreed with Taylor up to the point that they went to buy beer at the BP station. After leaving the station, Palmer said Taylor asked him to go to the Shoney's restaurant and ask for money from someone who worked there, but Palmer said he refused to do so. In order to get from the gas station to Shoney's, he would have passed in front of Captain D's. Palmer said he walked halfway to Shoney's and turned back. By that time, Taylor was already in Captain D's. He went to the door and Troy Snell allegedly opened it for him. Palmer said, "Bebe was telling me to get the money. I said no. Then I heard her asking them, 'Where is the money?' Then I heard 2 gunshots. It sounded like firecrackers going off. I remember seeing 2 of the people in the back on their knees. This was before they were shot. When I heard the shots, I was standing in the front counter area." He said he left the store and ran back to Tiffany Taylor's apartment. Several minutes later, LaTonya Taylor arrived, covered in sweat. The sister asked why was she sweating and what she had been doing, and Taylor replied, "Nothing. It's hot outside." The 3 victims were killed with a single shot from a .22 caliber pistol. The murder weapon was never recovered, and Troy Snell did not take his own life, as a gunshot residue test performed as part of his autopsy was negative. We will never know exactly what transpired at Captain D's and behind the Kmart store, but this we know for sure. Either LaTonya Taylor is one cool customer, or she had no conscience. The morning after the murders, her mother picked her up at the apartment at 7 a.m. and took her to her job at the Santa Fe Cattle Company in Hermitage, where she worked her regular 8 to 2 shift. They had no choice but to drive right in front of a parking lot filled with police vehicles at the Captain D's. After the arrest, the court machinery started to turn, and as is inevitable, hiccups began to present themselves. Judge Don Ash appointed attorneys to represent the defendants, but in April of 2002, one of the attorneys was disqualified. Alan Hale was appointed to LaTonya Taylor's defense team, but was removed due to the appearance of impropriety. An inmate named Jocelyn McCrary said she had shared a jail cell with Taylor when she was jailed on an unrelated charge. McCrary said she had obtained information on the case from Taylor and approached Alan Hale. Hale testified that he notified the district attorney after he was contacted by the inmate. McCrary said that the Smyrna detectives and the TBI asked to speak to her after she was contacted by Hale. Even though Hale told the court McCrary was not his client, he was still disqualified. Judge Ash said that Hale had information on the case and failed to disclose it to the court. Hale told Judge Ash he did not ask to be on the case, but rather was appointed. That was a bad idea. Judge Ash replied that either Hale or his representatives had asked for him to be placed on the case, saying, "It didn't come to me in a vision." Not only was Hale removed, he was ordered not to discuss the case with the remaining defense attorneys. The district attorney asked that the entire defense team should show why they shouldn't be disqualified because Hale put himself in position to be a potential witness. He subsequently filed a motion to have the entire defense team removed because defendant Taylor could claim ineffective trial counsel should she be convicted. Judge Ash later ruled that the attorneys would stay on the case. Also in April, the prosecution filed a motion to have the trial separated. The prosecution's motion stated that they planned to introduce statements made by the defendants about the participation by action and word in criminal activity about their co-defendant. If the defendants were tried together, the prosecutors might not be able to introduce the statements, and the prosecution felt that would not be fair to their case. In June of 2002, another problem came up with the defense attorneys, this time with Gerald Melton, the appointed public defender for Percy Palmer. Melton filed a petition to have himself removed after it was discovered that his office previously defended a potential state witness. Melton's motions included a letter he wrote to the State Board of Professional Responsibility stating that Jocelyn McCrary and another former client heard Percy Palmer make a statement concerning the murders. The state's disciplinary council gave his opinion to Melton that it would indeed be a conflict to continue representing Palmer. Judge Ash said he could see a problem with the situation and advised Melton's co-counsel to begin considering another attorney for the defense team. The judge set another hearing for the matter and on June 17th released Gerald Melton for the case. His decision set the stage for yet another delay. Palmer's trial had been set for February of 2003, but other death penalty attorneys hesitated to join the case, saying they might not have enough time to prepare an adequate defense. Ash anticipated that the trial could be delayed 3 to 4 months while other attorneys came up to speed on the case. Finally, in September of 2002, trial dates were scheduled. The next February would be Taylor's original date with the jury, while Percy Palmer would face a June date. The judge set an October date for the police to turn over all evidence to the defense. In December of 2002, the defense attorneys began trying to save LaTonya Taylor from the possibility of the death penalty by showing that Taylor had received a diagnosis of mental retardation while she was a teenager. In the state of Tennessee, a mentally retarded person cannot face the death penalty. District Attorney General Bill Weitzel didn't buy it, saying that mental retardation had to exist at the time of the offense. He asked to have Taylor evaluated at the Middle Tennessee Mental Health Institute in Nashville. As seemed inevitable, the prospect of delays loomed again. In late April, Patrick McNally, the attorney for Percy Palmer, appeared in court, saying he was having trouble obtaining documents from California, where Palmer once lived. Attorneys for the prosecution said that Taylor had been evaluated as an outpatient in Murfreesboro and indicated they would file a motion to have her evaluated in Nashville. Judge Ash set a May hearing date on those motions. In May of 2003, Judge Ash scheduled Palmer's trial for November 2003 and indefinitely delayed Taylor's trial. At the time, Taylor was undergoing her mental health evaluation in Nashville. Also in May of 2003, a new wrinkle appeared. The parents of Troy Snell utilized a new victims' rights law and filed a court motion seeking speedy trials for those accused of their son's death. And I, for one, don't blame them. The Snells had been fixtures in the courtroom throughout the process. Their son had been in his grave for almost 3 years at this time. By June of 2003, it had been some 21 months since the indictments were handed down, and the process had been repeatedly delayed. At that time, there was no end in sight. On May 30th, 2 weeks after their motion was filed, Judge Ash assured the Snells that he was trying to resolve the cases, but had to follow procedures required in death penalty cases. He said he wanted a resolution as badly as the Snells did, but the procedures he had to follow were designed to limit the time period for appeal